this court or no other court is hopefully going to do anything to violate your First Amendment rights or anyone else's First Amendment rights. But do you believe that conduct has to be a certain way in certain locations? Do you believe that? So, yes. Courtroom setting at this moment, do you believe that you could stand up, scream, yell, do anything that you wanted to in this courtroom at this point in time?
No, Your Honor.
Do you believe that there will be consequences should you do that?
Yes, Your Honor.
Absolutely. Kind of equates to the window at the clerk's office. The Chief Justice's administrative order, for your benefit, I posted it the second time. If you go back and look at your video, you may be able to see it on there or not. It was posted in the hallway, all right? But I posted it a second time after you came in with that encounter. But I'm going to read in part. Common areas does not include any counter or window or immediately adjacent space used by the clerk of court's office for conducting court business with the public, and the use of electronic devices in such areas is prohibited. The second time that you came in, and you were held in contempt, and even in your email, you challenged the order of the Chief Justice of the Supreme Court. He is not the only one that runs that court. There are other men and women that I'm sure is much smarter than anybody in this room, or they wouldn't be where they're at. Okay? It appears that personally and professionally that you've attempted to defame me and the court. You have attempted to allege that I'm a criminal without proving any criminal act. You posted it to YouTube, internet, sent to news outlets, alleging that, I believe the words were, that I'm a crook, that I'm unfair, unbiased, and things of that sort. What you done at that time is you committed slander by the words against me in this court. You were liable, being that you put it in print. And the fact that you sent that also through email to also the other respondents, it demeans the operation of this court. It demeans any power that this court has. In chambers and speaking with both counsels, I spoke to them about character and reputation. Character is your actual character, is what you do when nobody's looking. And I believe your reputation is what people think of you and what they say about you. I've done my best during my whole career to keep my character and reputation intact, period. I am not going to allow you nor anyone else to ever take that away. I have my own family. And when I go home at night, I want to lay my head down and have a proper conscience about the things that I do. Do I like being here addressing this with you today? Absolutely not. Did I like it when I come in and seen it, and then you had the audacity to not only post it online, but here you go, send it to me in email. All right? That's like taking a needle and trying to stick it at somebody's eye. All right? Did I like it? No. Did I jump off the handle and go crazy? No. I think I'm better than that. You've indicated to some extent, I'm not going to state, you indicated that I only had a high school education. I don't know where you got that from. I'm a lay court judge with now over 25 years of experience, a total of 34 years experience between law enforcement and judicial services. I do have a college education, and I have well over 1,000 or so hours of judicial credit hours. I study, I read, I told counselors that I may not be the most best spoken person, but I just don't decide what I want to do. That's what I'm going to do for the day. I put thought and effort into it. I've worked hard to provide for my family, and for somebody like you to want to come and tear me down in the public, above being a probate judge, I'm an elected official. That is demeaning to anyone. I'm not taking it personal. I'm assuming that your fiance, whatever you call her, you call her your wife, or whatever she is to you, it appears to me that you just fall on a sword from her at the drop of a dime. That you would take that sword for her, whatever, whether she's right or wrong. Her issue will be taken care of on another day. But I'm telling you, sir, your conduct with this court is done. You've also alleged that I illegally kicked you out of this courtroom and that I later denied it. I never denied it. I will put it on the record now. What I told you on that particular day, You had this judge, regardless whether you knew who she was or not, speaking with somebody else out in our lobby. You intentionally interrupted her and told the person that she was speaking with about the proper filings of paperwork in probate court for them not to pay attention to her, that probate court did not know what they were doing out there, and that she should come outside and talk to your wife, that your wife knew everything about probate. If your wife knew everything about probate, I guarantee you, you would not be sitting here today. Your wife would not have to be here next week if she knew everything about probate. I don't think there's anybody that absolutely knows everything about probate. I know I don't, but if my best practice, if I don't know it, I don't do it until I get the best answer. But you, sir, for you to do that, I had every right to prevent you from coming to this court. This is a public place, but I had every right to keep you out to protect other people. Do you understand that?
Yes, Your Honor.
All right, you don't have to look up and think about it. If you don't, you say you don't.
Well, no, I understand what you're saying, Your Honor. I think some.
But do you understand that offering legal advice is illegal in this state? You understand that?
I don't know about that.
No, but I'm telling you.
You're telling me that I do.
In my 34 years experience, Mr. Chambers, would giving somebody legal advice, would that be unlawful practice?
That's absolutely. That's
okay. All right. Don't take my word for it, but I'm telling you, your conduct is enough. It is enough. And after today, it's going to end one way or another. Today, it stopped. I hope you understand that.
I do, Your Honor.
There was no fine amount in the world that would have prevented your conduct. I wasn't going to bring this portion up, but I am now because it's even more concerning to me. There's no doubt that you are a well-educated and a very intelligent person. I don't know if you've ever been studied for your common sense abilities. That I have no idea. I'm going to leave that there. I'm not going to try to demean you in any way. You have an absolute right to a First Amendment. And as I spoke to counsel previously in chambers, to some extent, I've lost my rights to First Amendment. When I became a judge and I took an oath, I don't get to go out here and say what I think about other people publicly. I don't get to publicly talk about politics because my job requires it. And if I want this job, then I'm required to do certain things. Yet you have a right like anyone else, your First Amendment. There's no way that I've ever got the ability to prevent you from exercising your First Amendment right. However, I can control your conduct when you come into my court. Probate court in any court in this state, the probate judge is elected by the people. So this is the people's court. This only judicial position in this state that's elected by the people of their county. The only position. And I refer to it as my court, being that I'm the judge of probate. I run this court. You don't, the attorneys don't, I do. Good or bad, I run the court. I've got somebody that's unruly that comes into this court, you can guarantee I'm going to take care of it. And as you know, I just did. So now you're here for the first portion of it. The thing that concerns me, Jason Bull is a man of considerable intellect integrity. His academic achievements include a PhD in chemistry and substantial postdoctoral work at the Navy Weapons Laboratory. Whatever anger issues you got, but then you done work with in a Navy Weapons Laboratory, that scares me to death. You came in twice. One, I think you probably knew that you shouldn't have done that to begin with, but the second time you definitely knew that you shouldn't have done that. Who's to say that the third time you don't come in with a weapon if you can't control your anger that much? Who's to say you don't do that the third time? I spoke to counsel about it, and I asked them, don't bring it up. But me seeing that you actually have assisted, helped, or done whatever with Navy weapons, I don't know what all that entails. But that is scary, and then you come in and want to intimidate and harass a court. All right, I'm a public official. I've got thick skin. That I can promise you. I've dealt with issues for years, being talked bad about, being talked good about, but I go back overall and talk about character and reputation. Regardless, at the end of the day, what you may think about me or maybe a few others, my reputation and character is intact, and it will be intact until the day I leave this office. That's a fact. That's for me to decide, not you. That there scares me. There's no doubt that you are very intelligent. Either you're very intelligent and you have no common sense, or either you're very intelligent and you got an anger issue. One or the other, maybe both. I have no idea. But your conduct with this court stops today. We clear on that?
Yes, Your Honor.
Briefly, Your Honor.
Yes, sir.
If I may, in regards to his work with weapon systems, he develops weapon systems. He doesn't handle any sort of naval weapon systems. He purely,
He develops them.
he develops,
Who's to say he takes a few chemicals at home and develops one there?
and that's my point, Your Honor. Just, if I may, I believe that his passion overrides his common sense, and it's not more. It's just,
I may very well agree with that.
I believe that's the case, Your Honor, and as an officer of the court, I can attest to that.
Okay.
You know, I certainly believe that that's the issue, that it's not really an anger issue, it's just his passion. Certainly, you know, can overwhelm him at times, and it is deleterious to his common sense. Thank you.
And I have indicated previously, just to make this part of the record, it was taken up in chambers. Mr. Chambers, you came in the first day that you appeared in court. The court provided you with every document you requested. Is that correct?
That's correct, Your Honor.
I indicated the concerns I have about his boldness in approaching the court and what would occur if he come back again a third time. All right. But I also indicated to you that I was well aware that they had a small child. And I gave you an assurance that I would not do anything to hurt a child or do anything to place that child DSS custody or whatever it was I said. I understand the child has a mother and a father. All right. Families need to be together. That's a problem with our society today, is families don't stay together. Okay. So I firmly believe that, and I'm telling you, got you. Okay. Your child has no harm.
Thank you, Your Honor.
Your child, regardless what I do with you today or what happens with Miss Pierce, what may or may not happen, your child will have no harm come to it. That I can assure you. Like I said, I've got my own family, and I wouldn't dare do that to someone else. Give me just one moment. We're going to go in. I'm going to make this part of the record. First of all, I'm going to make sure to make clear to you that, you know, again, making false allegations, publicly posting that a judge of probate court in Oconee County is crooked and committing crimes. That is unacceptable. And to accuse me of being uneducated, that might even be more offensive to me. I've worked hard for this job. You understand that?
Yes, Your Honor.
All right, and I'm no way telling you to delete whatever you have. You have it. The only thing I can do is prevent you from recording.
I will delete it, Your
But
Honor.
I'm not telling you to do that. If you choose to do that, I believe that would be beneficial for you. And if if you're a man of your word, then you're going to do what you say you're going to do.
I always do.
Because, all right, well, I promise you, I'm a man of my word too. And like I told you, this conduct stops today.
And Your Honor, I can provide confirmation, of course, to the court, you know, that he has deleted it once he gets the opportunity to.
You said that he has deleted?
No, Your Honor. I said I'll provide confirmation to the court on his behalf that he has deleted it once he gets a chance to do so.
All right, this email looks like you've ended up and had one read indicated there was a good read about another judge in the lower part of the state, and whereas I was quoted in the article being president of South Carolina Summer Court Judges Association, but anyway, you indicated that was you were excited about this opportunity. It looks like we can help many people by publicizing this disaster of this probate case as it arose out of the actions of an ignorant judge in a case that included his childhood friend. The judge, due to bias and ignorance of the law, was dependent on the guidance of a lawyer with interest in the outcome. This has been stated to Ms. Pierce repeatedly. The Pierce respondents, where did you get that I was their childhood friend? Where do you get that I even know them? Do you have a response for that?
No, sir.
Okay. Then I'm telling you, if I wasn't a judge, I would swear myself as a witness and testify, but I can't do that. But what I can tell you, I do not know these individuals, never broke bread with them, never played with them, never rode a school bus with them, never went to school with them. Your lie is not everybody else's truth. Ms. Pierce has been repeatedly told that I do not know these people. So I don't know how you can continue to say these things about a sitting judge, and more likely you know the truth because nothing presented to the court, one that this court or myself has committed a crime. There's been nothing presented to this court with any affidavits, testimony of any witnesses that I know any of the Pierce respondents. Mr. Doyle Pierce, I never knew that gentleman. Make sure it's understood today. Do you now understand that I do not know these people? I have no interest with them. Do you understand that?
Yes, Your Honor.
But yet you want to continue to repeat that lie. You understand that's not true.
Yes, sir.
I want to make sure you understand. You go back out and say whatever you want to later on. Your First Amendment right allows you to tell a lie. If you want to go out and lie to the whole world, you can lie. Okay? But you can't do it to defame somebody else with their being a public official. You just can't do that. All right? Again, I've already talked about you being liable and the slanderous comments that you make. All right? Conduct towards the court, attempting to intimidate a court official. These things are illegal. If it continues, then I won't have any options but to pursue those avenues. I would much rather take care of the way it's being handled today and be done with it. Mr. Chambers, do you consent that Mr. Boyd posted this video along with one prior to that? This right here was the edit of the first. I'll save some time.
Yes, Your Honor.
Do you consent that he posted those to YouTube?
I do, Your Honor.
Okay. All right. Mail of Friday, February 24th, 2024, 7:48 p.m. Thank you for including me in this conversation. What a nuisance subject. I believe the Supreme Court ruling is absolutely incorrect in accordance with the First Amendment. I recognize the challenges of addressing this discrepancy, yet I think it is worthy of clarifying the terms of the First Amendment. Here's a copy of the video. I very intentionally did not record a third party in the lobby. My contest is that you would have to justify a violation of privacy. Again, that's no violation of privacy. It's public area. That's the order of the Chief Justice of the Supreme Court. I will look forward to your reply. Thank you for this opportunity to contribute to the well-being of this great nation. If I can be helpful in any way, I'm excited to be of service. I can be present at any time. P.S. I added a member of Oconee County Sheriff's Department to this email. I do recognize that may draw interest. I have had conflict with Oconee County Sheriff's Department. This gentleman has been added because I believe he may be a good and upstanding law enforcement officer. I would hope with transparency issues will be clarified. It's attached to a thread in which Ms. Pierce is included, so I'm not going to go into that. Second, another email, May the 28th. Dear Judge Singleton, is email your preferred method of communication? I assumed it was from watching you and Dorothy communicate. I am easy to find. You do not need to send the sheriff to ignore all the no trespassing signs and enter our property illegally without a warrant. If you want them to enter the private property through a no trespassing sign, they need a warrant. Let's meet in your office. Give me a date and time that works for you. I will be excited to be served in person by you. All right, for you to be excited to be served by me in person, am I to take that as a challenge, or how am I to take that? That you would be excited to see me to receive notice?
I'm just saying that if you want to serve me, I'll happily come down.
No, but I will be excited to be served in person by you. It should have been sufficient for law enforcement to do it. I'm not a process server. I'm not a law enforcement officer. That's part of their job. But we'll clarify, regardless, absent of this, that is not your property. That property is in an estate. It is not yours. You may be residing there at the moment, but that is not your property. Do you understand that?
Yes, sir.
You reside there. That's not your property. You're not the owner. Mr. Chambers, I think I'm done. I will preserve that videos for any type of appealable issues or anything further. Do you have anything else you'd like to add before I make a decision in this matter?
Briefly, Your Honor, yes, I would just like to reiterate that as Your Honor has seen today, Mr. Boyle indeed contrite, recognize the errors of his ways, and that we would ask that you, if you find him in contempt, that a monetary fine would be appropriate, and to give him another chance to tabula rasa, to prove that he will be a man of his word. He'll delete the videos, and that he'll in fact have no further communications with the court. He's learned from his ways. Just give him a second chance, Your Honor. Thank you.
All right. Thank you. Mr. Chambers, like a better word, you've been somewhat of a blessing to be involved with this case or become involved with it. I believe things went much smoother today with Mr. Boyle having counsel, and for that, I appreciate it. Mr. Boyle, these are some serious issues. The day and time in which we live now, government, according to some people, government is eroding. People think they have no respect for government, no respect for rule of law. I'm required to take an oath, and I'm required to be bound by that oath. And I try to take that oath as serious as I can. I come to work. I try to provide a safe place for the employees that work here. I try to provide them with a good work experience. In general, when the public comes here, I generally try to provide them with a good experience. The majority of folks that come in here deal with grief. We understand that. People, their loved ones have died, and now they've got to go through the treacherous paperwork of trying to administer those estates. However, you got some that don't want to play by the rules. All right. And so then we have to deal with those individuals. I believe that I was in law enforcement. Robert Kennedy once said that each community gets law enforcement to some extent, that I believe that each community should get the court that they deserve. And the fact that you come in, you're doing things the proper way. We're here to assist and do whatever we can. But if you're coming in here and misappropriation, which there's nothing's alleged in that particular state, but misappropriations, misconduct, and things like that, then you need to get the court that you deserve. Today, you're going to get the court that you deserve. I do find you in direct contempt of court. You've already served a sentence of 10 days. Court hereby sentences you to 60 days in the county jail. And I would suggest that you abide by everything that you indicated and gave word as a gentleman that that's what you would do. But your conduct is over with this probate court. You understand that?
Yes, sir.
All right. I'll issue an order, have it sent to the jail this afternoon.
Make a
Thank
statement,
you.
Your Honor.
Sure.
Can you please not incarcerate my wife while I'm incarcerated?
That issue, as I told your attorney the other day,